Presiding. Please be seated and come to order.
Good morning. Good morning.
Good morning.
Do we have any preliminary matters before the jury comes out? Yes. Could you put your microphone on for me?
I have a motion.
Yes, your motion?
Your Honor, this is a motion to dismiss the trial pursuant to due process requirements of the 14th Amendment of the United States Constitution. For the Commonwealth's knowing use of false testimony tainted the trial and must be dismissed pursuant to Napue versus Illinois. I have the cases, Judge, and I can submit those to you. I've given some to counsel. Unlike a motion to strike where we're talking about the sufficiency of the evidence, now the defense is making a motion to dismiss under Napue versus Illinois. This is incumbent upon the moment that you realize what the violation is. And as of yesterday, when the Commonwealth closed, with no detectives, with no evidence relating to the digital forensics, which no evidence relating to the catfish, which has been what they've said all along. It was at that point when they rested that this became incumbent upon me to make this motion. Usually this motion is made in conjunction with a Brady request that's not complied with. It stands for the proposition that if the government knowingly uses false testimony, the trial is tainted, not just for credibility issues, and must be dismissed. In this case, and actually in Napue, the government failed to correct the testimony of a witness co-defendant who stated he was given nothing in exchange for his testimony when the prosecutor knew he was to receive favorable treatment from the sentencing court. This knowing falsity was enough to taint the trial, requiring reversal. For this, a bit of background is required. In September, the Commonwealth gave me a list of probably 65 witnesses. That was the last filed witness list with, that was probably when Mr. Clean was still on the case. There was no, pursuant to the discovery order, any witness list filed for the Commonwealth. It was only when I reached out that I was able to get a list of some names that they potentially might be using, of which Detective Miller, who's the digital forensic detective, was not on there, nor was Detective Bryant. In fact, there were very few police witnesses other than Detective Leach, who we did hear from. As the court notes, you've had this case from the beginning. You've seen the battles for Brady material, which we know were violated because ultimately what came was concluded to be Brady and was known to the Commonwealth back in November of 2024, in fact, even before that. Speaking specifically as to the things that were known or should have been known, is Detective Miller, for Fairfax County digital forensic expert at the time, did an executive summary that was in the October timeframe. In that, he says that Christine Banfield, he concluded that Christine Banfield never lost control of her devices. And it was she who was reaching out to Mr. Ryan and others on BDSM websites, thus thwarting the theory that the defendant was part of a catfishing scheme to lure Mr. Ryan to the Banfield home to set up a double murder. Detective Miller's report was sent to be peer-reviewed as the chain of command did not like its findings. That peer review was concluded and they concurred with Detective Miller's report. This was known a year before Mr. Banfield's arrest and coincided with Juliana Perez Magalhaes' arrest. During the almost 1 year that Juliana remained in jail, Juliana's counsel requested 2 continuances and never secured a digital forensic scientist. And it's unknown if he knew about Detective Miller's conclusions at the time that he decided to take to advise his client to take the actions that she's taken. When the co-defendant decided to accept the reduced plea for time served and her mother counseled her to take the plea and blame it all on Brendan, there was a highly unusual event for Fairfax County wherein the lead prosecutor for this case, Eric Klingen, questioned and interviewed Juliana in the presence of her counsel and some police detectives. In that video interview, she gave a statement in which multiple occasions of her version did not line up with digital forensics and could not have occurred. Detective Miller was then pressured by the detectives in the case to alter his findings to fit Juliana's story, to which he declined and prepared his summary for the homicide unit. He was then transferred without a request to the child exploitation unit. It can be concluded that as of October 2024, the police and the Commonwealth attorneys knew the evidence did not support the catfishing theory. In October 2025, when she gave her first recant, there were police and prosecutors in there, yet the prosecutor was the one that was questioning. The absolute unprecedented upheaval of the homicide division has been well documented and is directly related to this catfishing theory that was pushed upon, and also by the unsupported evidence. At the defense motion for bill of particulars in September, the court asked, is this still a viable alternative for the Commonwealth to prove catfishing, and the Commonwealth committed to that. However, as the evidence ends yesterday, Judge, we have nothing but Juliana Perez Magalhaes. That's, as to the motion to strike, I understand the court's position, but these findings and the evidence to support the finding that the Commonwealth knew or should have known is it within every aspect of this case at this point. This is essentially a lack of candor issue, Judge, with the court, and it's in violation of Virginia State Bar Rule 3, which requires candor with the court. Rule 3.8 requires the Commonwealth be the minister of justice, not just an advocate. Further, 3.8 requires a prosecutor to withhold indictment if there is no probable cause. At the time of Mr. Banfield's indictment, the police knew about Detective Miller's findings, and Ms. Perez Magalhaes had not changed her story and accepted the Commonwealth's plea deal. These ethical requirements have not been met. But more troubling is the presentation of false evidence by the co-defendant. It is analogous to a prosecutor presenting the testimony of a victim in a rape case, knowing the DNA exonerates them, but doesn't present it. This known falsity denies the defendant a fair trial. This should be dismissed pursuant to Napue versus Illinois as violative of the 14th Amendment. And there are additional cases, Judge, which I have for your review, which are closely aligned with Napue, which is the seminal case.
I'm familiar with those cases, but thank you, Mr. Carroll, if you want to.
Would you?
That's fine. Yes, ma'am?
Thank you.
Thank you.
Your Honor, counsel has highlighted the Commonwealth's witness list containing 65 people, most of whom we did not call. I expect the same to be true of defense, and that is the nature of a case. When we want to make sure that we do not limit ourselves should evidence be required, we list a witness on that witness list, which is provided to the court well in advance of trial. In this matter, we called the witnesses that we believe presented the evidence clearly to the jury. We have presented the physical evidence collected, we've presented the DNA analysis, we've presented the blood evidence, and there is no requirement that we call a lead detective to present a narrative when we in fact have the person who was in the room to present that narrative. In this case, counsel argues that Juliana Perez Magalhaes presented false testimony. That's a matter for the jury. Counsel simply doesn't like what she said. That doesn't make it false. At this point in time, Judge, I don't believe that there's any merit to this motion, and we would ask you to deny.
All right. Anything further?
No, Your Honor.
All right. I am familiar with the Napue cases and their prodigy. The Napue cases are a little different from here because in those cases, they're based on a prosecutor's failure to correct testimony that he knew to be false. That's not what we have in this case. There's no evidence the Commonwealth is using false testimony. It's just the weight of the co-defendant's testimony that does go to the jury. I don't have any Brady violations at trial at this time, and none have been alleged. The Commonwealth has presented their evidence, which has survived a motion to strike, but I cannot find any violations of the 14th Amendment. At this time, the co-defendant did provide testimony as to a catfishing theory. The way the Commonwealth puts on their cases up to the Commonwealth, I don't have any evidence or showing that the Commonwealth has used any false statements, testimony that they knew to be false. So therefore, I'm going to deny your motion, okay?
Thank you.
All right, yes, sir. Are you going to start with the evidence, the exhibits?
Yes.
Okay, that's fine. Have we gone over them?
Yes, we have, Judge.
Okay, and do you